Hello and welcome to Let the Record Show, a Sivia Law podcast. I'm Todd Sivia, the owner of Sivia Law, where we help you through life's transitions. Welcome to our podcast. This is our first one. We're really excited about getting this started and getting this going. Through the pandemic, I was doing several live videos and I had a lot of feedback with regards to those, and it took us some time to really get into the nitty gritty. But today we're starting a podcast. I'm humbled to be here to talk about the different topics that may happen in the world and kind of give you our comments on what's going on and how that impacts you as a middle American. So let's talk about two of the biggest mistakes that attorneys make with regards to estate planning. Anybody that handles estate planning, they're usually find they're solo practitioners and there's one or two people in the office and they're trying to knock your estate planning out and get it done and get your wishes established. Well, one of the things that, what we have found and with a case that we handled was the attorney drafted a trust. It was about 4 pages long and was very, very basic because when I sit down with most clients, they just want it simple. They don't want anything fluffed up. They don't want anything crazy. So, their attorney was following the instructions. Well, what happened was they wrote down all the wishes. They had split the estate how they wanted it. But unfortunately, the beneficiaries just didn't like how the split turned out. So over the course of a 3-year period of time, the trustee of the trust fought back the beneficiaries. And all that needed within that trust that probably would have stopped the entire litigation was a clause called a no contest clause. It's very, very simple, probably about a paragraph long. And in that clause, it says, if you fight it, you get nothing. That is probably the biggest thing in a nutshell, is that if you disagree with how I set things up, you get nothing. And so if you file a lawsuit, you contest it, you do anything in your power to fight how the split is, then this would be a disincentive for any kind of litigation. There's always structural issues within a trust and things of that sort. And if there's a vague term, it kind of gives it the ability to get into those issues. But in this case, the beneficiaries cost themselves $150,000. Our law firm was able to successfully resolve that case because of that, because it was pretty clear that the client wanted the beneficiary to be split this way, and they could not find any arguments against it. So the court finally won, but it took us 3 years and over $150,000 in attorney's fees. So I know for sure in our estates, there is a no contest clause within all trusts that we draft. But if you don't have one, make sure that you've reviewed your estate plan to ensure that that is in your plan. Here's the second mistake. One of the things that most people do, they establish wills, they establish a trust, they establish whatever their estate plan is. The problem is they never get it funded. And I think that's probably the biggest thing with any kind of attorney is that handles any kind of estate planning. If you have a plan, that plan needs to have all your assets follow that plan. Here's a common example. I had a client that had a will. In the will, it says that it was like 3 or 4 daughters or 3 or 4 individuals were supposed to be split this amount of money. Well, the problem is mom put the one daughter on the bank account as a joint owner. Well, she had over $100,000 sitting in that account. My advice to that daughter was, well, you get to keep it all. So you don't have to split it with your other sisters. There's no legal obligation to do so because you are the owner of that account at the time of death. So that's not what mom wanted. She wanted it to be split. Well, her beneficiaries weren't established. So even if you have like a will, and your beneficiaries or your estate is not set up the way you want it, you got to make sure that it's funded correctly. And most attorneys, when you establish a trust, you have the trust, but then they stop with the funding. They'll put the real estate in, and then they say, you go and fund it yourself. Well, the issue with funding it yourself is, one, you really don't know how to do it. Most Americans don't really understand a trust in itself. And two, they don't know what they're supposed to do. Even if you have legal guidelines for that, it's not very, very clear. So funding is very, very important. So if you're listening to this and I did a trust for you many, many years ago, please give us a call, 618-659-4499, because I will make sure that you're funded. We do send out notifications to clients, but we have made a very major turn in the estate planning world to ensure that we are doing that. So any trust coming out of our office from here on out will be funded, and it'll be part of the cost of doing an estate plan. So, that's pretty big issue. I didn't learn any experiences from that, but I do see things happen fairly often. So, we were talking about that person that owned that checking account at the end of mom's life. What did she end up doing? Well, she ended up giving her 1/3. So she still had that moral obligation to complete that gift that mom wanted. But here's the issue. Because it's now in her name, there's gift tax laws that kick in. She can only give $16,000 per year per person in order to get that money transferred over. It's not an easy task just to hand over a portion of that estate. It required them to go a couple years before that could kick in. So it is a mess. There are laws that kick in if you give over a certain amount. So trying to do post-mortem planning, there are some hiccups with regards to it. So it's not just some simple way of, oh, I'm going to give everything to this person and then they will distribute it. That doesn't necessarily work out very well. Those are the two common mistakes that most attorneys will make when they do estate planning. So, like we talked about, one is having a no contest clause within the estate, and two, funding. Like I said, funding is a huge, huge issue. So, and for our awesome listeners of this episode, we got two special gifts. One, if you were a former client of mine and there was a problem with regards to funding, or you really have a question about funding, give us a call. We'll make sure that your estate plan is funded correctly. So call us. If you are a new client and you live in Missouri or Illinois and we can assist you, by mentioning this podcast, we will give you 10% off of your estate plan. But make sure you mention the podcast to honor that. So that's it. Remember, if you have questions about this topic or anything else regarding estate planning, probate, or anything else, you can visit our website at www.sivialaw.com for our blog and more resources. I'm Todd Sivia, the owner of Sivia Law, where we help you through life's transitions.